Good afternoon. This is Justice for All, and I'm your host, George Yates. We'll be here for the next couple of hours. We have a very interesting show today. We have two expert DUI defense lawyers here today to talk about the law of DUI, defending DUIs, refusals, all that kind of stuff. Anybody that drinks at all sometimes might have to find themselves getting behind the wheel of a car. Unfortunately, it's something they're not supposed to do, and occasionally people do it. And the law isn't you can't drink and drive. The law is that you can't drink after you've had too much to drink. And sometimes people make that mistake, and they're pulled over and they're arrested. And that's what these two guys that are on the show today are dedicated their professional lives to, defending folks arrested for drunk driving. We have two guests. We're here in the studio with me today is Mike Tillotson. He's a DUI specialist. His practices is based in Newport News, but he practices DUI law all over the state, and he's written the go-to book in Virginia called Virginia Practice on DUI. And he's here with me today. How you doing, Mike?
I'm doing great, George. How are you?
On the phone with us from Massachusetts is Steve Jones. Steve is a nationally recognized expert in DUI. He is the dean of the National College of DUI Defense and has a very successful practice in Massachusetts and tries cases actually all over the Northeast, defending DUIs in front of juries and judges. How are you doing, Steve?
I'm doing great, George. Thank you.
Well, this is the kind of topic, Justice for All, we've been on the air now for several months, and I have these experts on who will tell us about the Supreme Court decisions, and they'll tell us about this. I get these very interesting guests about that are experts on all these topics, but this whole thing about DUI is the one subject that I seem, no matter where you go, people will ask you a question about a DUI. What should I do if I'm confronted with with something like that? And it's just a subject that almost everybody knows something about, either their friend or somebody has had an experience with it. And anyway, I guess I'm going to go ahead and start off with you, Steve. What is a DUI or a DWI, or what is drunk driving?
Well, the acronym changes from state to state. It could be OWI, operated while intoxicated, or DUI. Or in Massachusetts, it's OUI, which is operating under the influence. So it just sets out really the elements of the crime itself. The acronym stands for driving under the influence. So they need to prove that you're driving a vehicle, and that definition varies from state to state. They need to prove that you're on a way or on a public way. I mean, I don't know of any states where you can actually get it for driving around in your own yard, but so they need to prove it on a public way, and then they need to prove that you were impaired. And that standard in and of itself changes, whether it be the on federal land to state to state. It's in Massachusetts. You have to drink enough so it diminishes your capacity to operate your motor vehicle. Yeah. And in other states it's different.
Mike, what do you say?
I'll tell you what, a couple things Steve said I get questions about all the time, and there are such big differences between states. And Steve, in Virginia, you actually can get a DUI in your own driveway. You do not have to be on a public roadway, and you don't even have to be driving. So you can, the standard in Virginia is that you're operating, and if you're sitting behind the wheel with the keys in the ignition in your own driveway, you can be arrested and convicted in Virginia. Virginia does not, probably the biggest question I get is what's the difference between a DUI and a DWI in Virginia? There is no difference in Virginia, but in a lot of states there are differences. In Virginia, DWI is driving while intoxicated. DUI, driving under the influence. The definition under the law is operating. So they're all the exact same thing in Virginia.
When we talk about, historically, this DUI thing has changed quite a bit over the years, hasn't it? How did you get involved in doing this, Steve? What made you, you got out of law school and you started practicing law and at some point became a specialist in this sort of area. How did you gravitate towards DUI defense?
Well, I started off as a prosecutor and prosecuted in Massachusetts for a few years and decided to had a young family, decided to go out on my own, and first worked for an insurance defense firm for a brief time, and just couldn't stand that. So I then opened up a practice, and I was doing all sorts of different cases. And throughout the early part of my career, I tried everything from the lowest level crime to first degree murders. And many defense lawyers won't like to hear me say this, but I gravitated to DUIs or OUIs because the people are regular people. I don't really like criminals. So I am defending people on something that is a judgment crime. The police officer thinks you might be under the influence, they arrest you. It can happen to anybody. Whether it be your sister, your aunt, your uncle, your teacher, your whatever it might be. So I gravitated to that for the to help people in a crime that's overcharged and overprosecuted, and luckily have been able to help a lot of people through the years. How'd you
get started DUI defense, Mike?
Well, I could echo a lot of things that Steve said. It really derived from the desire to help people. And I went to my first national DUI conference in 1998 and realized, gosh, how many things can be wrong. I mean, there are about 20 different ways that the breath test can be wrong. Field sobriety tests, which they use to convict people, are just basically a bunch of coordination exercises, and not everybody can do those. And so people can be falsely accused and falsely convicted very easily. Nobody likes drunk driving, but you do get the school teacher or the truck driver or the military officer whose their careers are on the line, and they get a false result on a breath test, and they didn't do everything perfect on the field sobriety test, and their life is ruined. And so Steve, he's our dean of the National College, such a great organization, and we just have a passion for representing people and trying to ensure that true justice is done.
Now, over the years, I know when I first started practicing, and I prosecuted DUIs and then defended them for many years, still do. It was so easy back in the old days. I say old days, 20 years ago or so, that it would be routine for a DUI to be, a first offender. It would be broken down from a DUI to reckless driving. Does that happen anymore, Mike? Or are they just routinely pleading cases down if it's a DUI and just agreeing that maybe they should be found guilty of something less? Or do you have to try these cases in front of judges?
It's extremely rare. The judges are under a lot of political pressure. I've had them even say, one in Virginia Beach, the judge said, I'd really like to help the guy, but it's either his career or mine. And he said it blatantly from the bench. If they're looked at as being soft on DUI cases, they could not be reappointed. So most of the time, I'd say the vast majority of the time, you have to fight and you have to go to trial.
Well, up in Massachusetts, Steve, I noticed from your website that you have deferred finding statute there for DUIs. Is that often a matter taken under advisement for a first offender?
I didn't hear the first part of what you said.
In Massachusetts, if someone is a first offender, is it possible to go to the prosecutor and work something out where perhaps they get a deferred finding and something less than a conviction in the appropriate circumstance?
Well, I guess the short answer is yes or no. First, it amazes me to no end how tough the prosecution can be on operating under the influence cases. If you're a drug dealer and they do these things by levels, if you have 28 grams of cocaine, it's one thing. If you've got 100, it's another. If you've got 300, it's another. And all these things have mandatory jail sentences. And even in murder cases, they'll negotiate oftentimes to a second degree murder or a manslaughter case. But if you've got a first offense, a second offense, a third offense, a fourth offense drunk driving charge, they're not reducing it. They're forcing us to try it. Now we're lucky in that we get juries and the judge still sentences afterwards. Unlike I understand where Mike practices, but it shocks me that the DA's offices will drop a drug dealer sentence to the next level down or 2 levels down to get a plea, but the drunk driver who's got a family and she might have a job and that causes her to use her car but they don't negotiate whatsoever. So something at some point just got ass backwards here, and they should be focusing on treatment and getting these people back to work and back on the street. Because I can't tell you how many people sit in my office and say, the 40-year-old school teacher and that says, I've done nothing wrong in my whole life. I thought I believed in tougher things on drunk drivings, but I've lost my license for refusing the breath test for 6 months. How am I going to get to work? How am I going to get my kids to school?
Well, now we have restricted license ordinarily on a first offense here in Virginia. Someone will get a restricted driver's license, and they can go to and from work during work if they use their license for work, to and from school, to and from child care, to and from even church on Sundays. So often the license provisions here can be very liberal depending upon how you work and what your work is. I think that a lot of the problems with this refusal to give anybody a break sometimes gets down to the type of work perhaps they have. Like someone says that, hey, a DUI conviction is going to cost me my job. If somebody is a roofer, and I'm not going to disparage roofers, it's honorable work, but if someone's a roofer, they get a DUI conviction, it's probably not going to cause them a problem. But a DUI conviction, let's say if you're in the Navy or you have some kind of security clearance or you work on the Navy base around here, it's a lot of federal workers. So a lot of people are trying to get out of the conviction itself. And sometimes there's just no compassion for that anymore. You run into that a lot, Mike, where you're trying to get them out of the DUI itself because the conviction itself for some people is actually much more onerous than it might be for others.
Oh yes, that's absolutely true. Like I said, people absolutely lose their entire careers. Military officers, for example, they blow an 08. The machine might be wrong. They really might only be an 05. They're not impaired, but they get convicted, and they not only lose their career, but they lose all of their retirement. They lose everything, their health benefits. So it has a devastating effect. One thing Steve mentioned, the refusal, and then you mentioned in Virginia, refusal is 1 year no driving at all. You don't even get restricted privileges on that. It's very much political, but the purpose is why it's become so political, or the reason is because of Mothers Against Drunk Driving, and obviously anybody that's been affected by a drunk driver, that's had a family member killed or injured by a drunk driver, they're going to be listening to everything we have to say and think, you got to be crazy. Why would you have any compassion on anybody that would get behind the wheel? But the fact is that they've not made it illegal to drink and drive, like you mentioned right from the beginning. It's illegal to drink enough to become impaired and drive. And that's a fine line. Where are you on that? And so there are, like I said, and I guess I'll keep saying it, there are innocent people that do get convicted, and that's where we're coming from.
Well, let's start right now. We've got two experts here. Both you guys try a lot of DUI cases. And I guess maybe we should do is trade a few war stories here between Steve Jones. If you just joined us, we're on K-Talk Radio 1650 AM. I'm George Yates, and this is Justice for All. And I have two expert DUI attorneys here, Mike Tillotson from Newport News and Steve Jones from Massachusetts. So why don't we start with you, Mike? I'm sure you've just probably tried a DUI in the last couple of days. How do you go about defending one? Why don't you give some examples as to how you, let's say, win a DUI, prevail on a DUI, get somebody cleared of this charge?
Well, I'll give an example, one from Virginia Beach. It was a gentleman's second offense. He was 63 years old. He blew a .13 on the breath test and failed field sobriety tests. It turned out the breath test was wrong. We had to bring in an expert. The prosecution had the state's expert. this individual had acid reflux, which maybe we'll get into later on. But it is one of the most common ways to get a false result on a breath test. The state will say it can never happen. But the judge listened to the battle of the experts. And the one thing that the judge commented on, which people don't realize, even prosecutors and other judges, is that these machines that we use in Virginia, and every state they're different machines in different states, but none of them anywhere in the entire country have ever undergone independent scientific testing to determine if the protections they have in place against false results actually work. So they'll say, we can protect against a false result. They'll admit that there can be, but they say they have protections in place. Well, when I cross-examined the state's expert and asked her that question, how many studies have there been, how many has the machine ever undergone independent scientific testing, the answer was no. The judge stopped the trial and said, wait a second. Are you telling me that we're using a machine in Virginia to convict people, take away their careers, effectively ruin their lives, and this machine's never been subjected to any kind of independent, peer-reviewed testing to see if it actually works? And her answer was, well, we test it at the government tests it themselves, but they really don't. You look at a government test, it's ridiculous. They're not doing scientific testing to see if their machines actually work. So then he disregarded the breath test number because we were able to show how it could be wrong. We had to deal then with the field sobriety tests. The guy's 60-some years old. Favorite question you ask the cop, are you judging my client the same way you would a healthy 21-year-old? He had other physical problems. Some of the tests weren't done right. At the end of the day, despite the failed test, despite the number on the machine, he found that there was not enough evidence to prove beyond a reasonable doubt that he was guilty, and found him not guilty.
Now, in that case, what was the probable cause for stopping him? Was it bad driving in the first place, or some other reason?
Yeah, it was raining. He was going to make a turn, realized it wasn't the right place, and so he went back out into the lane of travel. The officer felt that was bad driving behavior and pulled him over.
How about you, Steve? How do you go about winning a DUI case? I see you've got a track record of a lot of success in defending cases in Massachusetts. What's your secret?
There are many jurisdictions in the country, and there are many lawyers who have a tendency to really take a scorched earth policy. The government is bad, and everybody's innocent, and never didn't do the crime. My stance on these cases is to really just create reasonable doubt, whether it be in the driving in Mike's case, where there was a reason why he moved over and crossed the lines, and that's a valid stop. And moving on into interaction at the car and how the person dealt with you. I mean, there's a lot of things that can be pointed out that really can dissuade a jury from seeing that this was proof beyond a reasonable doubt that the diminished capacity was there. I take the stance of, there's a lot of standards. The police arrest on something called probable cause. There are other standards between probable cause and beyond a reasonable doubt, and they run the gamut. I mean, as an example, in a civil case, as George and Mike, the standard is preponderance of the evidence. So if one side has 50.1 and the other side's at 49.9, the 50.1 percentage, that's enough. Then you've got another standard called clear and convincing evidence, and that standard is used oftentimes in when the state feels that somebody's an unfit parent, and they have to prove by clear and convincing evidence, that they're unfit and shouldn't have a child. Now, beyond a reasonable doubt is even higher than that. I mean, when you really put it in perspective, and you put in perspective that, you've got a case where you're taking someone's child away, you'd want to be pretty darn sure that you're doing the right thing. And beyond a reasonable doubt is an even higher standard than that. So, we do a lot with medical records and perhaps injuries that people have had. The GERD or acid reflux defense is a phenomenal defense on breath tests. We in Massachusetts and many states around the country, on the breath test that shows the volume in liters. You have to blow a certain amount of time and a certain amount of liters of air. And, whether you've got acid reflux or GERD or whatever it might be, or you're just blowing real hard, you're going to get some stomach air in there. And the stomach air is much more powerful or concentrated for alcohol than air coming out of the lungs. So I sort of live in the trying to just create reasonable doubt, whether it be the unfair field sobriety testing. I mean, and it is unfair. I mean, these officers, they demonstrate these tests and they say that they're reliable and they can do them but they do them every week, if not every day, on some of the active officers. And then you've got this poor person, and they've been up for let's say it's midnight, and they got up at 6 in the morning. They've been up for 18 hours, and they're in front of a police car with the lights flashing, and they're asked to say the alphabet. It's that's a nerve-wracking scenario. You miss a letter, and all of a sudden you're in the back seat of the car. Or they ask you to walk a line, and I'm 57. Nobody 57 is the same physically that they were at 27 or 20 or whatever it might be. Fatigue has an effect. I mean, there's all sorts of reasons why somebody might be nervous or certainly tired, and they don't conduct an investigation at the side of the road to see how long they've been up, ask if they're fatigued. They don't conduct an investigation. They're trained a certain way, and that's effective for them. And don't get me wrong. I mean, they're getting people who are under the influence off the road, but they're also getting people who aren't under the influence off the road.
Do you try all your cases to juries?
No, it depends. I'd say I've done about 50 cases this year so far, and I would say maybe 35% are juries, 35 or so percentage judge, and then the balance is the case gets dismissed for one reason or another. So
right.
That's, and I mean a complete dismissal. And we do have, in reference to an earlier question you had, we do have this something called a continue without a finding, where you admit that there's enough evidence, and you do a program, and at the end of a year it gets dismissed, which all sounds well and good. The problem is it still counts as a first offense if you get another one.
Right.
It's still on your driving history if an employer looks at it.
Right.
I mean, talk about a scarlet letter. It's gone from Scarlet A to a Scarlet D.
We don't even have that, Steve. We don't have that opportunity.
If you've just joined us, this is Justice for All. I'm your host, George Yates. I'm here. This is our special DUI show, and we have two expert DUI defense lawyers here. We're going to come right back with Mike Tillotson and Steve Jones to discuss defending DUI cases in Virginia and nationwide.
Fink's Car Care, with locations in Chesapeake and Portsmouth, is your dedicated Tire Stars dealer. At Fink's, their experienced staff specializes in brakes, steering, suspension, tune-ups, oil changes, and much more. They also handle rebuilt engines and transmissions, and they're your destination for tires, rims, and towing as well. Fink's is located at 2236 South Military Highway at 2711 Victory Boulevard. For more information, log on to finkscarcare.com or call 545-3573.
What is the progressive movement? Tell me what it is. A benevolent dictator? A benevolent government that takes care of every single need? Show it to me where it's ever worked. Show me why you believe this time it's going to be different. Progressivism disagreed with only one concept of communism. Only one. Revolution. That was it.
Glenn Beck, weekdays, 3 to 6 p.m. on K-Talk 1650.
For the very best in down-home music, join us on Saturdays, 11 a.m. for Ramblin' Ralph's Bluegrass Special with the authority on bluegrass music, Ralph Coleman. Saturdays at 11 a.m. on AM 1650 WHKT. Ramblin' Ralph's Bluegrass Special.
The
place for authentic Indian food is the India Palace. They feature authentic Indian cuisine, have a party hall, and do catering and banquets. Open daily for lunch and dinner, they showcase an excellent lunch buffet at their Chesapeake and Virginia Beach locations. Visit their 2 locations at 1437 Sam's Drive in Chesapeake off of Battlefield Boulevard and 5600 Virginia Beach Boulevard in Virginia Beach, and online at IndiaPalaceVB.com. On Facebook, look for India Palace Virginia Beach and India Palace Bar and Grill. Dine at the India Palace today.
Okay, we're back. This is Justice for All. I'm your host, George Yates, and if you've just joined us, I've got Mike Tillotson. He's a DUI expert defense attorney from Newport News, and a nationally recognized DUI expert attorney from Massachusetts, Steve Jones. Since so many of these DUI convictions do rest on this machine, I'm kind of fascinated by it. I just had a guest on last week, Bob Fisk, and we were talking about polygraphs. And polygraphs aren't admissible in court, I guess, because a lot of people can fool them. But this is definitely a conviction by machine. It seems more than anything else. These breathalyzer machines. So, Mike, first of all, what is the history? When were these breathalyzer machines? When did we start using these things? And tell me your read on breathalyzer machines. Which one do we use in Virginia right now?
We use in Virginia right now, it's called the ECIR2. It's electrochemical infrared, and it's the second one that they've produced. That's why they call it the 2. The EC electrochemical uses a fuel cell to measure alcohol. The infrared uses light to measure ethanol molecules, alcohol. And they have the capability to do 2 measurements and measure them against each other, but they had problems, and so they turned off the IR component as far as quantitating alcohol. So they only used the fuel cell part to actually give a number, because they were finding too many variances and the machine would mess up. So they just turned it off. So the IR part is not used. It's only used to detect alcohol. But as far as the history, in Virginia, interestingly enough, in 1916 was the first DUI law, and that was the year that Virginia mandated prohibition. So that's interesting. And then the first documented case in Virginia was that used a machine was in 1953. But it wasn't commonplace. But back then that machine was called the drunkometer. And since they've been using machines in Virginia to convict people for DUIs, the Department of Forensic Science has said basically it's infallible, but they keep coming out with new technology, new machines, but yet still the other machines were still infallible despite all the new technology. So that's how it goes.
But you're actually a breath tech operator yourself. You've actually taken all the training to be a breath tech operator. So tell us how the machines make mistakes.
Well, like I said, there are about 20 different ways, and Steve can expand certainly on a lot of it. I just want to talk about two ways, the most common ways. We mentioned it already, acid reflux. The machine is supposed to be measuring your lung air, and you get ethanol, alcohol in your lungs from the blood. So when you drink alcohol, it goes into your stomach, into your intestines, and then into your bloodstream, and from there, it goes into the lungs. You blow into the machine, they measure it. There's a ratio from the amount of alcohol in your blood that gets into what gets into your lungs, and that's 2,100 to 1. That's an assumed ratio. Actually, the ratio can be as low as 1555 all the way up to 3,500 to 1. But the state makes an assumption and says everybody has a 2,100 to 1 ratio. So that means 2,100 alcohol molecules, ethanol in your blood. One of them will go through this partition wall into your lung air, and that's the formula that they use. When you have alcohol in your stomach, obviously it's never even gotten into your intestines. It hasn't gotten into your blood. So Steve was mentioning, when you're blowing into the machine, you can actually have ethanol fumes coming up from the stomach at the same time as you're having ethanol coming from the lungs. The machine cannot differentiate where that's coming from. It's contained in the same sample. So a preliminary breath test device, one that they use out at the scene, does not have any protections, therefore it's not admissible. But you can take any PBT and take a drop of alcohol on your tongue and it'll go crazy. The one that they use at the police station is supposed to have a protection and flag it if it goes up too high from stomach alcohol. Then you're supposed to see a drop. It's called a slope detector feature. You're supposed to see this negative slope. But if there's no negative slope to detect, so if you're breathing a sample and it's a continuous breath, continuous mixing of the alcohols, there will be no negative drop-off. And so you can get a false result, and it doesn't take very much at all. You know, when you talk about a 0.08 on a test, George, you know, you're at an 0.08. Do you know what that means? That means 8% of a gram per 210 liters of breath. That's how it's defined. 210 liters of breath is 105 2-liter bottles, right? And that's of air. It would be enough to fill up a 55-gallon drum if you were to dump 210 liters into a drum. And so when you're talking about this measurement, you're talking about 8% of a gram. It's really, if you wanted to term it in ounces, define it, it'd be in the millionths of an ounce. So it only takes a little bit of alcohol coming up from the stomach to blow this thing out of the water. And the state's protections just have not, as I mentioned, been scientifically tested to see if they actually catch it. And I think that they rarely do. That's one way.
Well, now, do you, and we'll get to the second in a minute, but just on that one point, do you actually hire an expert then to come into court to talk about, I mean, you're the attorney. You can't be the expert in court. So do you have your client hire an expert to come in and testify to what you've just explained to us here?
Yes. Unfortunately, the judges in Virginia get training from the state and are told that the protections work. And so we have to bring in an expert. Some judges will listen. A lot of them do. Some just won't listen to any of that. But yeah, unfortunately, the defendant is at a big disadvantage because the burden is on us, even though it's supposed to be innocent until proven guilty. I think in DUI cases, a lot of times here, at least in Virginia, it's guilty until proven innocent. So we have to bring in experts.
And Steve, do you use that acid reflux defense quite often in your cases as well?
Well, if it's there, I like to have a situation where somebody has been treated for it, whether it be just, speaking to the doctor about, indigestion and getting, being told to take Tums, to, much more severe, forms of it, like Barrett's esophagus, and in the middle is, gastroesophageal reflux disorder. And what it is this: these disorders, the reason you're getting acid into the acid is leaving the stomach. There's something called the esophageal sphincter, and that is the thing that is right above the stomach, and it's like a valve, and it keeps everything inside the stomach. Well, when somebody has acid reflux, that causes the esophageal sphincter to relax, and that causes the air that's in the stomach, and the stomach, because of that sphincter, is a closed container. It's got liquid in it, food, and then it's got air above it. And similar to many breath testing devices, which have something called a simulator. In other words, the machine runs a test on itself, and it tests this air above the liquid in the simulator to determine if it's reading it correctly. The stomach is very similar to that. When the esophageal sphincter is closed and stays closed, you've got this air above the liquid in there, and that air contains alcohol, just like it does in the simulator. So when you are blowing air into the machine, you are supposed to be getting just deep lung air. Well, if this sphincter is relaxed, and air is coming out of the stomach, or in some cases it's not even relaxed, and I'll talk about that in a second, you're mixing air from the stomach, which has not been which has not gone into the blood, which has not gone into the system, and it can be 50 or 100 times more concentrated for alcohol. And as Mike talked about, how small of an amount, talking about this 50-gallon drum, a small error can cause a very big error when you're reading, stomach air. And what I do oftentimes with juries is talk about the fact that, and most of the Commonwealth's or the state's witnesses are going to agree that, belching is not a good thing. They watch you for 15 minutes to see if you're belching or regurgitating or doing anything, because they are taught that the belch or the burp, that's bringing that stomach air in, and it can contaminate things.
Well, now you can have you don't have to belch or burp in order to have acid reflux, or do you?
No, you don't. But even still, yeah, because that air is flowing up with the air from the lungs, because the esophageal sphincter is relaxed or not working properly because of the acid reflux. But in addition to that, you don't even necessarily need acid reflux to get that stomach air in. And what I tell juries is, I want you to go back to the jury room. You heard the expert talk or the police officer talk about the fact that a burp can affect it and stomach air can affect it. I want you to take your thumb and your forefinger and make a hole, and then take a deep breath and blow into it. And you can feel, when you do that, your stomach contract. Mm-hmm. That contraction is forcing air into the esophagus and out the mouth, and it's commingling with the air from the lungs.
So Steve, do you really just say that these machines are just unreliable because it's so random that you can't ever really know for sure whether or not someone might, that this air could be coming up? And are you basically saying they're unscientific, they're unreliable in general?
I'm not saying that they're unscientific and unreliable. Under the best possible circumstances, with an individual who doesn't have any issues, and whether it be the partition ratio, what Mike was talking about, 2,100 to 1, and the variance. I mean, if you've got that average person there with no difficulties, with no problems, then the machine can work and does work in some circumstances.
If you just joined us, go ahead, Mike.
You also have to put this in the perspective of the rest of the evidence in the case. If you've got a 0.16 or 0.18, or I've seen it happen on a 0.24 breath test, where the jury just didn't believe it because the person was, didn't have the field sobriety. They had results on field sobriety testing that were borderline or even good. And they're supposed to hold their foot up for 30 seconds. They held it up for 22. Or they walked the line and they just doesn't go exactly heel to toe. Or any number of other different things. So, it really helps in these cases to have what we call a disconnect, where the physical things that are observed by the officer don't match the breath test. I mean, if you got somebody that, they open the door and they fall out of the car and they're obviously completely hammered, and you got a 0.18, well, the acid reflux defense isn't going to do you very much good.
Yeah.
But if you have a disconnect,
right,
and that can even come in the form of the fact that somebody's got medical records talking about or testimony talking about the fact that they've got a bad ankle and they've had it since they played football in high school or since they did gymnastics.
If you've just joined us, this is Justice for All. I'm your host, George Yates. We're having our special DUI show today with Mike Tillotson, a DUI specialist, defense attorney from Newport News, and nationally recognized DUI expert, dean of the National College of DUI Defense, Steve Jones from Massachusetts. Mike, you were talking earlier about this, and I was just going to make a comment myself that this acid reflux thing, it would appear that you're going to have some kind of previous medical diagnosis of this in order to use it effectively, or does somebody just come up at the last second and say, oh, gee, I have acid reflux? If you don't have a a previous history of it, how are you going to be credible on that?
Well, we've won cases with that defense just by bringing in family members, testimony that they've had it. A lot of people
Heartburn?
A lot of people treat it by taking over-the-counter Prilosec, the little purple pill. I mean, it used to be prescription; it's over-the-counter now. So yeah, we still present the defense.
What's and what other ways can you beat the breath machine?
Well, George, I wanted to tell you that for the listeners out there, this is something that's real important to understand. Is that the machine can be wrong, like we said, about 20 different ways, but the second way, most prevalent way, well, maybe not overall, but there's other ways, but this is a common way that it can be wrong. People that are diabetic or people that are on a low-carb diet. How big was the Atkins diet? See, when the Atkins diet, what happens when you are diabetic or you are on the low-carb diet, your body goes into a state of ketoacidosis, and your body produces ketones. Your body, then those ketones break down into acetone. And then acetone further breaks down in the body to isopropanol. And isopropanol is a type of alcohol. So what the machine is measuring is ethanol. Now, there's I think there's about 40 some different types of alcohols. So when you're getting isopropanol from in the body and it's getting into the machine, even the manual for the ECR2 manual says that the machine is only specific, meaning it can only test for alcohols. But for isopropanol, things like that, again, the state says, well, we've got something in place that's going to detect that. Well, show me the scientific study that says that they can. And oftentimes they can't. And so you have these cases where you're getting a high number, but like Steve talked about, there's a disconnect. The field sobriety tests aren't that bad, or you have some good explanation. And here you go. You've got somebody that's been dieting that could end up being convicted of a DUI when they're not guilty. So that's a big common way that somebody can be falsely convicted. There are a lot of other ways, but in the interest of time, we'll talk about that later.
Well, now you said, what about diabetes? You mentioned the diet. How does diabetes affect the breathalyzer machine?
The diabetics are producing ketones as well. It's that chemical breakdown of the ketones ultimately into the isopropanol, the type of alcohol that then is naturally existing in your body. And that's what the machine is reading in combination with maybe ethanol in your body. It's combining those two. We put on seminars on the breath test machine and put ketone into an ethanol solution and tested it before and after, and the machine's producing a much greater result with the not ketone, the isopropanol, which is rubbing alcohol's isopropanol. So you can put a little drop of rubbing alcohol in with ethanol, and you're going to get a higher result.
What do you say about that, Steve? Do you use that same sort of defense with the breathalyzer, with the ketones?
It can certainly be used. It's not something that I have done that often, if at all. The diabetes defense. One of the questions that, and it's a great defense, but one of the questions that used to be asked, and is frankly no longer asked by the police officers, when they get people back to the station is, are you a diabetic, or do you have any issues with your blood sugar? The great thing about, and great is the wrong word, but the thing about diabetes is, low blood sugar, high blood sugar, issues with blood sugar are going to make somebody appear also intoxicated. Loss of motor function, loss of fine and gross motor skills. And so, I have a tendency to go in the direction of observations on a diabetes type case, then, the issues with the ketones and the chemical part of that. It's just a difference in preference. In Massachusetts, we have a sort of a wide swath because most people in Massachusetts refuse the breath test. So, and I would say, it's up in the 60%, 70% range.
Wow.
We're dealing with mostly refusal cases.
Now,
and
when you get a refusal case, now here, what ends up happening is people will refuse, and then the government can come in and convict them on the field sobriety tests alone, and then they run the risk of being found guilty of both the DUI and the refusal. And of course, here, as in Massachusetts, under the refusal, you can't get any kind of restricted license. So people here often make that mistake. They refuse, then they get to court and they realize, oh, I'm going to be convicted based upon these field sobriety tests, which is what I wanted to get into next.
Well, the refusal in Massachusetts, it's not a crime. It's not a charge. It can't be used against you. So if you refuse field tests or you refuse the breath test, that cannot be used against you in Massachusetts.
Right, but you still lose your driver's license, correct?
You still use your driver's license, and it depends on what offense it is, how long it is, and a refusal can range in length of license loss from 6 months to life.
What happens here, though, often is someone will come into your office and they'll say, well, gee, if I'm found guilty of the refusal, what happens? You say, well, you're going to lose your license for a year. And they go, oh, I can't live without my license. And you say, well, the only way you can keep it then is to plead guilty to the DUI. So they end up with a DUI conviction, really in a case where the DUI evidence against them might have been marginal. Doesn't that happen, Mike? In order to get your license or so that you can keep your driver's license, you have to maybe plead to the DUI when maybe you weren't guilty of it.
Yeah, that's true, George. And there are some jurisdictions where they don't drop the refusal on a plea of a DUI. So if you refuse, you could certainly end up being convicted of both. And then it'll be 1 year on the refusal, no driving, and then 1 year on the DUI after that year where you get restricted privileges. If it's a second offense, refusal, though, it's 3 years, as you well know, George. In Virginia, it's 3 years of no driving. It's a criminal conviction, and you can get up to 6 months in jail just on the refusal. Very serious penalties for refusals in Virginia.
You know, Steve, you were talking earlier, something that's always bothered me, and I think you... I'm guessing have used it very effectively. And that's this comment you made about fatigue. You know, when somebody's been up for 18, sometimes more, 24 hours, been working hard all day, they're exhibiting the same kinds of behavior as someone that's been under the influence, and they might not have had anything to drink. Have you used that effectively in the past, the fatigue defense, that somebody's just not under the influence, they're tired?
Oh, I use it I use fatigue in virtually every case.
It's amazing because I've read a statistic that somebody, and so often people are flat out chronically sleep deprived. If you go several days and let's say have only 6 hours of sleep several days in a row and you're sleep deprived, you can have the equivalent of a 0.10 just walking around without having any alcohol in your system. Now you drink just a little bit, you're not even anywhere near the legal limit, but you might be exhibiting the same kind of behavior as someone who's got a much higher BAC. Is that what? And Mike, I think you want to talk about this.
Yeah, George, there's actually, and Steve well knows, and uses it, I'm sure, but there's scientific studies that support that fatigue, you can exhibit all the same symptoms of being under the influence of alcohol, except for basically odor of alcohol. Other than that, you're unsteady, your speech can be slurred, your eyes can be red, absolutely.
And then you're unable to pass these field sobriety tests, which I went to a seminar one time, and they called them field calisthenics, because you're expected to get out there and do these field sobriety tests that they're really hard to do for anybody. And I'd like both of you guys to spend some time talking about these field sobriety tests. A lot of people are familiar with them. Here in Virginia, we use that horizontal gaze nystagmus test. That's the one with the pen. The other is the walk and turn, and the other is that one-leg stand. Is that the ones you use in Massachusetts, Steve?
They give all three, although the horizontal gaze is not admissible in Massachusetts. in
all?
99.9% of the cases.
Wow, it's just not scientifically reliable. The judges
Well,
have just
you have to be you almost have to be an instructor and have given it and done research yourself on it. So it's one of our appellate cases indicates basically it's not admissible. And so we don't really have that. And the federal system is really just I think they can use it to show that you're positive for alcohol. So even the feds, don't really use it to any appreciable degree.
The police officers that I talk to, they swear by it. They think that they can predict the level of blood alcohol before they even take the person's blood alcohol in the machine. They think that they can. We'll say that they can determine where the eye is jerking and all that vertical nystagmus and all of that. Mike, where do you come down on the field sobriety test with all those three tests here in Virginia?
Well, just to address the horizontal gaze nystagmus, the eye test, what you said is true. I'm certified on the field sobriety test, and my instructor was a former state trooper that taught all state troopers in Idaho. But we actually were able to do it, and the earlier the eye starts jerking, the higher the alcohol content. And assuming that the person doesn't have any other medical conditions or there aren't any environmental conditions out there that are affecting it, it can be an accurate predictor of alcohol. But it is very scientific, and there are a lot of ways that you can exhibit nystagmus, jerking of the eyes, other than from alcohol. And the other thing is that one thing the judges don't realize here, in our state, some judges accept it, some don't. You can exhibit signs of nystagmus, that jerking of the eye, with levels as low as a 0.04 of alcohol in your system. Your eyes could start to do that jerking, and so it can be an indicator. But there's so many ways. If you have flashing lights, or if you've had concussions, that's a big one. Someone that has a history of concussions, they're going to have some jerking in their eyes naturally. And there's a bunch of different ways that you can have nystagmus. As far as the walk and turn and field sobriety tests and the one-leg stand, even if you miss a couple of those things and you say you didn't perform it correctly, and so they mark it off, even assuming you fail, quote, fail the test, they've studied it, and it's only like a 68% reliability that you're impaired, even when you fail it on say, like the walk and turn. The one-leg stand, I think it was like 62%. Interestingly enough, they've come out with a new manual, and they've increased those percentages without doing any further any more studies. But somehow the percentages just increased. But yeah, the way that we deal with field sobriety tests, basically three ways. How they were conducted, they have to be conducted correctly to have any validity. The environmental conditions, I mean, you're talking a roadway, it has to be flat, level, smooth, not raining, all dry, all this kinds of things. So you look at that. Are there rocks in the road? And then, of course, you look at your client. They can have all kinds of different physical problems. Fatigue is one of them. There's a cognitive aspect. People that have attention deficit disorder have a hard time. 9-step walk and turn, there's a series of 8 different instructions given to you while you're standing in a starting position, being pulled out of your car, having to listen to all this. And then if you don't remember to do all 8 of them and do them right, they're saying you're drunk in court. So it's not fair. So obviously there's a lot of ways to attack the field sobriety tests.
That's always been one of the most remarkable things to me, is that you'll fail that 9-step test because you didn't take the turn exactly properly. I mean, you're getting all these instructions in advance, and how many people listen that well, even in the middle of the day, to their honey, I forgot to get the eggs when I went to the grocery store. Oh, I must have been drunk then, because I forgot your instructions. Right. If you've just joined us, this is Justice for All. I'm George Yates, your host. It's been fun. We've been here for an hour with our 2 DUI experts, Steve Jones from Massachusetts and Mike Tillotson from Newport News. When we come back, we're going to talk about some more about expert DUI defense in Virginia and nationwide. This is Justice for All. We'll be right back.
The best of News Talk Radio, AM 1650 WHKT Portsmouth, The Answer.